So this is Ben Franklin. You know, he was at the 1754 convention. We'll talk about that a little bit more. But you know something? You know, I've showed you this before in the Tale of Two Constitutions, is that proposed amendments and conventions. Look at that. 10,431 proposed amendments up through 1990. Through 98, another 578. Another 530. So up to pretty much the present, which there are others, and this is right out of the Senate's website, so the Senate has all this up there, is that we've got 11,539 proposed amendments to the Constitution. Okay, how many have made it? No, how many total amendments do we? 27 amendments out of, you know something, I think the process works. Somewhere along the way, the process works, folks. You know what? Additional conventions. All right. I'm going to talk about these two in a minute, but prior to that, you know, first convention that you can go look up on the books, 1740 to about 1750, or 1640, I'm sorry, 1640 to 1654. The northern colonies came together in convention relative to their protection, and it was the Puritans that came together and got together trying to keep what was happening with the attacks of the tribes, to negotiate not only what was happening with that, but also between themselves as the colonies. It wasn't a very effective, because they still had some issues, but they went to convention to determine what they would put together as a policies and procedures. About 1680, there was another one that was placed on the colonies by the king. And the idea was, again, to form a compact of those colonies, once again, to stand strong against the tribes and to bring together the colonies as a more unified environment. Sorry. Oh gosh, about 1690, that fell apart. We can keep going, and what started happening, again, because of what was happening with the tribes invasions and attacks and everything like that, came to about 1754 in the Albany Congress, which they came together in convention. And guess what? There was this guy, kind of young and dapper at the time. His name was Benjamin Franklin. And what he proposed was that the colonies would unite together under one Congress and allow for an appointed, king-appointed, overseer, but that they would be a united American colonies. Oh, interesting. 1750, and they came together. They sent delegates. Each one of the colonies understood what it would take to assign, elect, and bring those delegates together for a purpose. Well, that was what happened. They did that. And you want to know something? That then became the model. That Congress, that convention became the model then for the Stamp Act Congress of 1764, and then the First Continental Congress of 1774. Isn't that interesting? A model of how conventions should work, a model how Congresses can work. You see, they knew about this stuff. It wasn't anything new. It went all the way back to the 1600s. How to elect a delegate. What should happen within the context of that? What should they agree on? What would be the rules? How would it form? What would be the outcomes? They thought about it before. Hartford Convention, 1814. The northern colonies, because of the War of 1812, they didn't want to take and give up their money and their troops anymore. They brought a convention together, decided what the roles of the delegates would be, what the purpose of the convention would be, how it would function, how it would operate. See, they went by the principles and the template that they learned earlier. You know what it was for? This convention was for secession. And the only reason they didn't secede was because this character by the name of Jackson in New Orleans kicked butt.
Right.
So it fell apart, the whole thing. The War of 1812 started coming to a slamming end, and so as a result, nothing effective happened out of that, but they came together in convention.
Right.
They knew the rules. Convention, conference, a peace conference of 61. That was to try and stop the Civil War from happening. What could they come together on? How can they make decisions that would keep the nation together? Obviously, it didn't work. They couldn't come to conclusions because there were people that were trying to amend what was happening, and as a result, the delegates said, wait a minute, we came here for a specific purpose. And you're trying to take and now submit things that are outside the context, the purpose of what this convention is all about. That's not acceptable. Guess what? We're all going home. Okay? Very interesting. So, with that, we had two things that were happening where conventions were trying to be pulled together. In 1969, the Supreme Court decision, it was doing what? Reapportionment. A convention was being called for to deal with that, to deal with reapportionment. Let's see, how many people were alive around 69? Yeah, just about everybody in the room that's willing to admit it. The point was, they were calling for a convention. You see, it didn't have to happen because there was enough pressure put on that Congress dealt with reapportionment differently, and the courts dealt with reapportionment. But pressure was put on by saying, the states are going to have a convention. We're calling for it. We want an Article 5 to happen based on what our constitutional rights are. Next, late 70s, early 80s, balanced budget. Who was calling for that? What was that character's name that so many people love in the Republican Party? Ronald Reagan. Ronald Reagan himself was calling for a convention of the states for what?
Balanced budget.
Balanced budget. Wow. That's pretty interesting. Here's a couple other things, just another couple tidbits, is that the reason that we have the 17th Amendment today, because 31 out of the 32 required states in 1913 all petitioned for a convention of the states. 31 out of the 32. So Congress, by virtue of then not having to go to that convention of the states, went ahead and passed the 17th Amendment. But see, that's another piece of the history that a lot of people don't understand. It was being pushed forward by 31 out of the 32 required. And the 32nd state was ready to go, but Congress then capitulated and put it into action of itself. So you see, none of this is new. So the discussion is not new. The states' rights are not new. It's an understanding of the principles by which we were given in the Federalist Papers, and then also from the states' conventions. And what they looked at was proper process procedures. Well, why do we want to, why now? Why now again are we trying to talk about a convention of the states and the pros and cons? Well, wait a minute. A lot of people have seen a similar picture of this, I'm sure, in the constitutional class. If you go to the 5,000-year leap, has anybody read that? You go into there and you look at the different pictures in that, and what Dr. Skousen was talking about was what would happen in a government. Well, some of the pictures are different. And we'll talk about that in a little bit, but this one here is where we are today. We have a nationalist government, folks. So what that means is that we see that Congress, we see the presidency, and we see the courts all the way into that position that is leading us to tyranny. And not only that, the relationship that the framers, and more importantly, the states then agreed to during the ratification process was the fact that the federal government relationship was not to you, the individual. That relationship was with the states, you see? And then the states had what? The majority of the authority. They had the majority of the authority to interact, and that was our relationship and flow of government. But the Anti-Federalists warned that if the government got out of control, that would shift. Federalism would go away. You'd have a national government that leads to tyranny, and it would reach down into your pocket. Anti-Federalists wrote, ladies, guess what? This government can get to your boudoir. This government can get to your tea. This government can get to your fine linens, ladies, if you're not careful, if you don't stand on self-governments. And gentlemen, to all your beverages, it would take and see you at the barber shop. This government would get to you to your barber shop. Anyway. So a pro is the right of the states to call for a convention of the state to amend, not to change the whole Constitution, write a new Constitution, no, to amend. And that is very clear in Federalist 43 and 85. Then the cons, which are coming from a lot of the great, wonderful neocon to conservative groups, they're saying, no, you can't limit a convention. You can't limit what you want to do around these articles. You can't do that. You can't limit it. That's not what Madison said. Madison said the only reason that we had that open convention was because we were allowed to. That was what was stipulated. We were given that authority to do virtually anything we wanted to do to make this a more active, exuberant government. Then they have on the pro side, for a convention of the states, is that, we have a process. We can follow the process. The con says, no, we're afraid. And, excuse me, I have to be fair. I get really riled up about this because I sometimes see that the cons sometimes want to manipulate as much as the pros. In all fairness, but I guess my passion towards the pros and my prejudice, so forgive me for my prejudice towards that, because we have a right to it. Yes. Okay, it's a right. And when somebody on the con side thinks that we're either too stupid or whatever, that infringes on my right, and I get upset about that. Yeah. So should you. You need to know the facts, you need to dig into it, you need to understand it, but don't let them take your rights. Right. And you have to stand on that. So anyway, a fear of a runaway. 87 was not a runaway. None of the other ones were runaways. They were all specific. There's rules, there's processes, there's things you have to follow. Okay, I guess you could have a runaway if you had all communists in there. Yeah. Just a minute, Joe.
It's verified that Congress, under the Articles of Confederation, back in 1787, green-lighted the proposed Constitution to send it out to the states.
They did. The Congress, under the Articles of Confederation, green-lighted it. They allowed it to go out.
And could have stopped it.
They could have stopped it. Absolutely correct. Congress could have stopped it. They could have said, nope, we're not sending it out to the states for ratification.
And they sent it out with that 9 out of 13.
Correct.
Which, as you said, technically stepped outside of what they had told.
Yeah, it stepped outside their authority on that because at that time the Articles of Confederation required 13 states. But the argument is that we're not going to hold up 9 states because of, or we're not going to hold up, 12 states because of 1 state. Okay? Because they argued, about what was happening in Connecticut because they felt Connecticut was corrupt and there was a lot of things that were going there, and Connecticut was this, Connecticut was that. Let's see, Connecticut was corrupt then, Connecticut is, oh, I'm sorry. Excuse me. I digress. History, you know, I do that time warp thing. Anyway, it's this thing is that 87 was called to revise and alter. They did that. They were called to revise and alter, and guess what? Yeah, they did exactly what they were to do, an effective national government, bring that into play. The cons say we have no George Washingtons, we have no Madisons, we have no Thomas Jeffersons. I'm going to let you know, folks, these pros and con elements, you could go to Tea Party Patriots. They have a symposium about Article 5, and you know they did some really great stuff, well facilitated. So if you have the time to go listen to those calls, please do it, because you know it'll take you. It's about about 5 hours, Vera? About 5 or 6 hours of listening, but I think they did an excellent job. It was well facilitated by a fellow from here in Arizona, and I think it was just very well done. But anyway, we don't have any of those people. Excuse me, I scratch my head and I go, you know what? Have you been studying the Constitution? How long have you been doing that? Are you a young fellow? How old are you? Are you like 30-something? 26. Oh my goodness gracious, you were about the age of Mr. Madison. Ooh! Dang, that's scary. You know, I've heard that, you know, and there's a TV, radio celebrity guy that talks about, you know what, we do have George Washingtons. We have George Washingtons. We have Thomas Jeffersons. We have Madisons.
Yes, we do.
You know that? We have them. Another pro is Congress is out of control. Federalist Papers expected the states to rein in via amendments. Madison says it. Even Hamilton, amazingly, even Hamilton says if the federal government gets out of control, it's the responsibility of who? The states. To get them back in check through an amendment process. Whoa, they're talking about Congress being out of control.
Yeah.
To rein them back in by what happened in '69. Just the threat alone of a convention caused them to do some different things. Geez, what's the thing about strategy? How does that work? Oh gosh, we shouldn't talk about that. Anyway, Congress will control the convention. No, the states, you know, Congress can try and say some things, but you know what? If your congressmen aren't doing the right thing, then you need to slapjack them silly.
Yeah.
If they're not paying attention and understanding this, I'm serious. You need to slapjack them silly.
Yeah.
I have no other way, you know, and like I said, I'm probably going to make some people really upset with me. You can limit it to a few amendments. Yeah, you can. The process allows for it. Let's see. Courts will control the convention. Wait a minute, I don't see anything in the Constitution anywhere that allows the courts to do it. Now, the progressives and all the other fabulous Democrat terminology that Mark brings out, you know what? Maybe they would try to pressure the courts and do a lawsuit that you can't have a convention, blah, blah, blah. But you know what? The progressive, straight-out Democrat communist want to have a con.
Yeah. Amazing.
Remember, that's not allowed.
Yeah.
So we have to stop that, but that doesn't mean that you don't have the right to have your state engage in a convention of states. You do. You're in control. And if you're not, you should be. You can't write a new constitution. The Constitution says that. Federalist Papers says that. History says you can't write a new constitution. The cons say they will write a new constitution. Okay. Pros and cons. Any result will require 3/4 of the states to ratify. You see, we got a ratification process. What did we just show? 10,000 some odd proposed amendments. You know, some of these were out of Congress. I mean, we got wacky Congress people right now that are proposing amendments. Okay? But they never get out of Congress. Or if they do get out of Congress, let's see, there's an amendment out there right now, and I can't think of which one it is, and I'm sorry that I didn't do my homework on it, that it's, you know, X number of states have already signed off on it, but it's not being it's not ratified. And then some people say, let's see, what amendment was that we all argue about that wasn't properly ratified? Okay, that's another story. All right. Liberals can control the convention. Well, then, you know, I have to say something, and I am going to be really crass. Then you're really stupid, people. If you take and elect the representatives to go to convention that are 100% liberals. I'm not going to allow that, and I don't think anybody in this room would allow that. You know, may there be some liberals that go to a convention? Absolutely. And you know what? That's okay. Even Madison said we should have the opposition there. You know what? That's what says. Yeah, well. Anyway, the fact is okay. But you know something? If you do what you're supposed to do in your state, and you have the proper representation in your state, the liberals are not going to control it. The method of ratification cannot be changed without three-fourths of the state ratifying that a ratification should be changed. Yeah. Come on, think about it. The process says that if you're going to change by amendment something, it has to be ratified by three-fourths of the states. So if somehow some squirrely amendment comes out that we want to change ratification to less than three-fourths of the states, well, guess what? It takes three-fourths of the states to ratify that. Oh, geez, that's interesting. All right. Oh, yeah, that's the con. They'll change the method of ratifying to less than three-quarters. Okay, fine. You know, maybe I should put the cons before the pros. All right. Grassroots activities educating the citizenry. That's you. That's what makes the difference. You know, but, you know, on the other side, they're saying the people are not educated or capable of understanding or doing what's necessary to stand up for their rights and execute their rights according to their God-given constitutional Declaration of Independence rights. Wow. I'm going to talk about an outstanding template. Francine said, what the heck's a compact? What's this whole thing with this compact of the states? You know, your bud, old Shane, you know, said, I'm on it. You know, I'm for it. I read that thing thoroughly, and we're going to go over it some. It's a template. It is a template so well designed from everything I talked about, historically significant, process perfect, that I call it an absolutely wonderful template. And you know what it'll do? It'll restore the federal system, the template, okay? The compact is part of that process, okay? And this is what Dr. Skousen talked about, is what our founders, framers, and ratifiers at the state conventions agreed to. This is the federal system. This is federalism, a balanced federal government that has a relationship to the states. So the compact is very interesting. It goes back to some of the things that I've talked about, that you've heard me talk about before. Compact has a direct correlation and relationship to covenant. So that idea, compacts have been around for a long time. What was the first compact? Mayflower. Oh, Mayflower Compact. That was between the people. Okay? And when states are doing a compact, it's the same thing. It comes from the order of the state legislators who you elect, which means they should be coming from the people, and that relationship between you and the state legislators that they then are able to compact with other states under the same principles, you know something? That's the compact. And this whole idea of this compact of the states, from the template perspective, the one that we're referring to and what Shane's referring to and that is for one amendment, a balanced budget amendment. Now there's a lot of argument you can argue about balanced budget amendment, whether that's the first thing to go after or not. That's not what I want to talk about today. That's a different discussion that we can all come back together and state opinions on. But it's a compact that brings together, and it's the template, this document. I mean, they did a great job. You can download it, you know. It's a fantastic document. It has definitions. The Article 1, it's a declaration of its purpose and intent, how it's supposed to work. And I'm not going to get into the details. We'll go over it. But I encourage you to download it. There are some things, and I don't want to take a lot of time because I want to open up for some questions too. But it becomes a compact between states, okay? And again, by order of legislature. Article 2, Section 1 through 6, specify that it's about a balanced budget. So they're picking one item, and they're doing it under the context of that compact and the definitions under that compact. As they progress through it, specifies the articles to what's going to happen next. How do you go about doing this? Who's the member states? What's the definitions? So it goes through any legal document. What does it all mean? Who's who in the zoo? Okay. Then what is a state? What's that consist of? I mean, geez, we got to be reminded of that even. What is a state? How does it function? Who has the rights? Who are the people? Who's the members? The members of the compact. Who's going to join this thing? What do they have to do to join it? What's the process to joining it? What are the roles, responsibilities? What are those things that they're signing up to? Because you want to know something? To join the compact, each and every state legislature has to pass a bill that they're going to accept the compact as it is. Right. They can't change it. You either sign up to it the way it is or just reject it. Don't participate. Geez, that's real interesting, isn't it? All right. Okay. Who at the federal level is going to receive the notices of the compact? You know, who all is going to get it? Congress, you know, the House, the Senate, Judiciary, the President, blah, 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 blah. You know, they're all defined. Then it goes through is the method of communication. You're going to email it, text it, you're going to take it, and what they're really doing, sorry Lou, what they're really doing is sending it either by courier, signed for, you know, because it's a legal documents, and so what they're doing is very, very specific means of communicating what's going on with the compacts, especially to the federal government, but even among other, and amongst the participant states, there's some definite rules on how it's going to happen. Then Section 7 actually gets into the body of the proposed amendment. So it gets into, this is a balanced budget amendment, so on and so forth. This is what it means, how it's supposed to work, etc. So the first section, especially under Article 2, is delineated in, you know, pretty detail. I mean, this thing, it's a detailed piece of work. But then it even gets more interesting. You know, then we start talking about how do you propose an amendment? Straight out of the Constitution, folks. You either do it in Congress or by a convention called by the states, 2/3 of the states, okay? Then there's two ways to ratify, either by 3/4 of the state legislatures or by 3/4 of ratifying conventions of the states, okay? So it can be done either way on the ratification. It can be done in the legislature, or they can call a convention of we the people, or whoever the delegates then that you would elect to that convention. Francine.
Which, as I'm looking at the two ways there, would be better, I mean, because when you're looking at, okay, by the state legislators, because then we the people are having to rely on
we the people are having to rely on our state legislators actually doing what we the people ask them to do. Or the other way I'm going to ask is, in other words, do we get to pick people then that would go to this convention to represent us? Because if we don't trust our state legislators, they could not ratify it even though we the people want it ratified.
And the answer is yes. I mean, the first off, to get into the compact, your legislators have to be willing to do what you want them to do to participate in the compact in the first place. So hopefully you're doing your job and you're re-electing those legislators because they're doing the will of the people, that the legislators then can be trusted to execute accordingly. And you know something? They outline it really, really well in this document, in this template. Or, same thing, is that I think that it becomes more interesting by ratifying convention, because to get the delegates in there, it leaves it even more wide open to a greater degree of the citizenry, and then maybe some of the other cons start playing into hands. If you're not doing your job with feet on the street, then those progressives are going to probably work on delegates and get their feet on the street. So it all comes back to we the people. It could be, or it could be worse, because then you're not doing your job and you're not getting out there encouraging people and helping them be educated and understanding what the process is. And so then the progressives are doing it because George Soros comes in with all of his money and all. Oh, did I say that? I'm sorry. Anyway, we have Article 3, talks about membership, withdrawal, and administration. How do you become a member? How specifically? What's defined in there? The compact governs each member state to the fullest extent permitted by their respective constitutions, superseding and repealing any conflicting or contrary law. Wow, that's pretty powerful, pretty interesting. Have you looked at this yet? No, have you looked at the compact? Well, the Liberty Amendment is different, but this is an interesting template. So if you're going to run for the legislature, John, I'd encourage you to look at it.
This is the first I've heard of it, but I am very interested.
Yeah, I'd look at it, because not only that, the details from a legislative perspective of the template for the process, this is phenomenal work. They did a great job. Okay, so you want to be a member? That's what you got to do. I'm sorry?
Before you leave that, the two ways to ratify, do we have a choice which way it's done?
Congress can help determine that, but it's also in here. So the interesting thing about the way that they define the compact, it has a lot of specificity to it. Did I say that right? Yes. Darn.
I'm bluffing, you did.
Yeah.
You have to say it 3 times fast.
Yeah, right.
No, I need to eat pickles first. But it gets real specific on some of that language and ideas on which methodology, so it touches on that. So there's a resolution in here that every state has to use the same resolution to apply to Congress. So it's all very succinct, very orderly. Everybody's doing the same thing. It's not a hodgepodge. So to participate in the compact, you got to agree all the way at the state legislature. John?
Is this what the Goldwater Institute has been advocating for some time?
Yes.
I have heard discussion of it on the radio, and I got interested in the whole convention of the states through that. And then, of course, I read Mark Levin's book. I just thought that there might be more. Mark Levin's book goes beyond simply a budget. There's a number of things he proposes.
Correct.
To bring into the government. But I think I've got nothing wrong with, as a first step, as long as it's understood that we could take additional steps thereafter.
Yeah, I do not advocate for the, personally, my opinion, I'm not an advocate of the balanced budget amendment first. You guys have heard me say, and ladies have heard me say this over and over, my first target is the 17th. If we can't repeal the 17th Amendment, this doesn't mean anything as far as a balanced budget. They won't honor it. They won't do anything with it. So anyway, we move on to Article 6 in here. And inside of Article 6 is delegate appointment, limitations, and instructions. Very specific. Very, very specific. Section 4 even requires them to take an oath. Okay? The delegates will take an oath, and the oath says, I do solemnly swear or affirm that I accept this appointment and will act strictly in accordance with the terms and conditions of the compact for a balanced budget, the Constitution of the state I represent, and the Constitution of the United States. I understand that violating this oath or affirmation forfeits my appointment and may subject me to other penalties as provided by law. But-
They're told to go with specific
Yeah,
instructions.
you know,
And they do anything else.
and it gets into what's their authority.
Right.
So, Section 6.
This was brought up, I went to the thing last night with Shane again, and they were going more of it. Well, it was brought up about, he asked, how many people know or have ever read the Arizona State Constitution?
Right.
Well, that was a very small number of people.
Right.
And, yeah, and then he said, do you know that an awful lot of the Arizona State Constitution was written by liberal progressives and is not constitutional?
Right.
That was an amazing little piece
Yeah.
of information.
Yeah, no, and it gets into that. But it, you know, that's what's really interesting is this, you know, specifies again what the delegated authority is, the delegate's authority, what their power is, what can they do, what can they not do. I mean, there's 1, 2, 3, let's see, 3 very specific items about their authority. Then order of business, how does it function? Forfeiture of appointment, you know, how the order of business is how they conduct themselves during the convention. Forfeiture of appointment, you know, they can, how did they lose it? And then their own expenses, or they're reimbursed, you know, for some of the things. So, you know, it's interesting. I said a template. This is stuff that our founders used. You know, this isn't something that Goldwater Institute just drew up. This is stuff historically sound. Historically sound. Okay? Article 7, convention rules. It's a whole bunch of rules on how the convention can and should function. And if it doesn't function according to this, guess what? It's an invalid convention and it needs to disperse. Geez, you know something? That happened in state conventions. You know, Massachusetts, they came together and put together their first constitution, and it went to convention and went to the people, and it was rejected. They said, no, you didn't include enough people in the drafting of the Constitution. You need to go back and do it again. And they did. Then it went back to convention with very specific rules, very specific ways, methodology. Holy smokes, you know, it took them 2 shots at doing the first Massachusetts convention. All right. Let's see, Article 7, convention rules. We did that. I pushed the up instead of down arrow. We're good. One more. Article 9, resolution prospectively ratifying the balanced budget amendment. This answers your question about ratification. Each member state, by and through its respective legislature, hereby adopts and ratifies the balanced budget amendment. See, they went with the states. So it's very specific how this is ordered. And remember, it's a compact. So every state has to understand this is the process that they're going to use for ratification.
Right.
So this is what is predetermined. Lastly, construction enforcement venue. Oh, gosh, I missed 8. Let me go back. Sorry. This was important. This one. The Ultra Vires Convention. This is really cool. Section 1. Member states shall not participate in the convention unless, A, Congress first calls the convention in accordance with this compact. B, the convention rules of this compact are adopted by the convention as its first order of business. Very specific. In other words, everybody gets together and they try and pull off some shenanigan. Convention's void, everybody pick up their toys and go home. Because it ain't going to happen. They sign off to this by virtue of rule, law, and responsibility. Then it goes into a couple other very specific actions. Yes, John?
All right, this comes into the problem of Congress having the choice to decide whether we're going to ratify by convention or in the state legislatures. It looks to me like Article 8 gives Congress an opportunity to torpedo the compact by saying, we want to have the legislatures. It sounds to me like they're saying it's got to be done this way, so Congress says, well, no. It's our choice under the Constitution. We're doing it the other way.
Well, and that's the chance. But you know what? It has to go through that whole petition process, and guess what? You better be doing your job, and everybody here better be getting their feet on the street and electing the right people to Congress as well. Okay? It all comes back to, what we're going to talk about next. Sir?
When the founding fathers were working within this paradigm, you didn't have 50 states. You had, 13 or so?
Correct.
And those 13 were demographically, I would say, comparative. You didn't have 50 states spread out all over the country with 50 different potential ways of thinking based on the type of state, the type of people that live there. So is there who calls the convention together, and who writes up what the amendments are going to be? And how do the 50 states agree on which amendments should be presented, which shouldn't?
That's why I think the compact is the way. And one of the things that you sound like a great anti-federalist, because that was one of the things that the anti-federalists said, is within these 13 states, we have such great differences, not only because of our geography, but because of our culture, because of our histories, because of our religious practices, because. So your first point of the discussion is absolutely what the anti-federalists were saying about the Constitution in the first place.
But it's a reality.
And it was a reality then. So your point is very pertinent to the conversation it is still the same reality as our founders and framers were dealing with. Well, the way they overcame that was by taking and bringing that representation and looking at one thing. It was the various states that came together on it because they recognized that there were problems with the Articles of Confederation. And so with the same thing is that we, the people, are taking and recognizing that there's problems with Congress, there's problems with our president, and there's problems with our courts. And so the system and all of the other groups up to this point in history haven't done anything to correct that. As a matter of fact, the enemy has taken more control over than what we intended to have. And that's when the framers and founders says then it's up to the states through the amendment process to take and stop Congress, to put a check on them. And with that then is that you have to have an organization or groups within the different states and the legislatures to come together and say, you know what, here's some good ideas. But we have a template that we can use. And then it's, if you form the compact, to take and then the states coming together and agreeing and ahead of time saying, you know what, let's form a committee. So for instance, there was a committee that came together at Mount Vernon in November. And that was a Convention of the States committee. And that committee came together for the purposes of discussing what would be good ideas for amendments, what would be the process by which would make sense to follow, and what could happen in the state legislatures, and can we get through the state legislatures. Now, let's go back, write up a couple ideas. The Goldwater Institute's floating this one around and has for a while. Here's an idea, and here's the process. And the process is historically sound. So can we finish and then we'll follow up with please hold your follow-up question. So it comes down to is that you need to be working within your precincts, within your legislature, to formulate what the heck's going on. And then how do we go about fixing it? And you need to have a voice in it. but it's our responsibility to communicate effectively. So I call this the outstanding template. And so I would definitely encourage you to go download a copy of it, because what they did also, which I think was fabulous, is they actually put it into a flow chart. I'm a picture guy.
Yeah.
You know, I like the words, but I really like the flow chart. So it goes through and it shows you all the various connections of how that compact operates, how it functions. And it goes through what is going on at the states, what are the states doing, what are their responsibilities, how that then goes into the process, including what Congress can do, can't do, all of that. This is up on their website, on the website for the Compact for America. And then, you know, what's the resolutions? How does it go back? How does it get ratified? So they take that document and make it into a simple flow chart. And I think it's just outstanding to go take a look at and to study and to see, you know, what makes sense.